Okay, let's continue our look at the court process. It is helpful to picture the criminal justice process, including the court process, as a funnel, like the picture in your book on page 179. You start at the top with all crimes committed, but police only hear about half of those. And out of that half, they maybe only solve about 20% of them. Out of those 20% that are arrested and start the court process, about 90% of those will either have their charges dismissed or will plea bargain. Only 10% go to trial, and then even fewer are actually convicted and sentenced. Here are the general stages a case goes through in the court process. Every state will have their own names for each stage, but generally this is how it goes. So let's start at the top. Once a suspect is arrested, they are booked at the police station. This is when the police record the suspect's name, charges, and get their fingerprints and picture. Once the suspect is booked, the prosecutor reviews the case to determine if there is enough evidence to charge this person with the crime. The prosecutor may decide not to charge the person. They may tell the police that more evidence is needed before they can be charged, or they may go ahead and charge them right then. The charges the prosecutor gives do not have to be the same as the ones they are booked with. If the prosecutor wants to charge the suspect, they file a charging document. That's the middle block. There are 3 different kinds of charging documents, and which one is used just depends on which state you are in. First of all, they can file a complaint, which is for misdemeanors or ordinance violations. They can file an information, which is for felony charges in states that don't use a grand jury. This is basically a written statement of the charges filed, the laws broken, and the evidence against the suspect. Or they can file a grand jury indictment, which is a written document by a grand jury charging the person with a crime. Once the charging documents have been filed, the suspect becomes a defendant and is brought before a judge for the initial appearance. This is when the defendant is given a formal reading of the charges against them and are read their constitutional rights. You might hear these called their due process rights. They have the right of notice of the charges against them, the right to a hearing, they have the right to counsel, the right to cross-examine witnesses, and the right against self-incrimination. In order for innocent people not to be held for a long time, the initial appearance usually occurs within 24 to 72 hours after being booked. And very often with lesser crimes, such as misdemeanors or ordinance violations, at the initial appearance, the defendant will often just plead guilty right then and be sentenced. They won't go any further in the process. If the defendant is charged with a felony, though, then there is a hearing to determine whether there is probable cause to hold the defendant for the preliminary hearing, or if they should be released while waiting for their preliminary hearing. If they are held, then the judge will set bail. So let's talk a little bit more about bail. Bail is a set amount of money that is given to the court as assurance that the defendant will appear in court when they're supposed to. The amount usually depends on the judge's perspective on whether the person is a flight risk, meaning they're going to run, and the seriousness of the crime. The person's previous criminal record and the overcrowdedness of jails also influence bail. People who cannot afford the bail often go to a bondsperson who will post the bail for them for a non-refundable fee, usually 10%. Bondspeople are allowed to go find defendants that don't want to show up and even forcibly bring them back. For people who can afford the bail themselves, they post the bail and are released, and then they get their full amount back once they appear in court. And if they don't appear, a bench warrant will be put out allowing police to arrest the defendant. Other options for being released are an unsecured bond. This is when bail is set but the person is released with no money paid, and then they will have to pay the full amount if they don't appear. There is also the possibility of being released on own recognizance. This is when the defendant will be released and just shows a promise that they will appear in court. This usually occurs with very minor offenses and where the defendant has ties to the community, so they're not considered a flight risk. Conditional release is similar, but the defendant has to remain in contact with a pre-trial release program, and usually a third person will vouch for them and supervise them. There are instances when the judge does not set bail and keeps the defendant locked up. This is called preventive detention, and usually happens when the judge feels the defendant is a threat to society. You see this most with violent crimes, drug crimes, and immigration cases. Often, though, rather than not allowing bail, judge will just set the bail extremely high. So, what is considered excessive bail? The Eighth Amendment guarantees no excessive bail. It doesn't say that bail has to be granted, though. What is excessive is based on the seriousness of the crime and the circumstances in which the crime was committed, the amount of evidence against the defendant, the character of the defendant, their past record, and their ability to afford bail. So let's go on. Let's continue this court process. For felony cases, about half the states use a preliminary hearing. This is when the judge determines whether there is probable cause to support the charges set by the prosecutor. The defendants can waive this hearing. They don't have to do it. During this hearing, the defendant can have a lawyer. They can call witnesses on their behalf. All this hearing does, though, is determine probable cause, not guilt. There is no jury for a preliminary hearing. If the judge determines there is probable cause, then the defendant is held for either a grand jury indictment or arraignment, depending on the state. Grand juries are used in about half the states and by the federal government. Their main purpose is to determine whether there is probable cause that the defendant is guilty of the charges. This is only for felony charges, remember. And then after this usually occurs, then they'll have the preliminary hearing. And don't get too bogged down with the exact order of everything, because I'm saying sometimes the grand jury becomes before the preliminary hearing, sometimes they come after, sometimes they don't come at all. It really just depends on what state you are in. So at this point, I'm just wanting to get an overall view of the court process, knowing there might be some changes depending on the state. Now back to grand juries. Grand juries are a group of 12 to 23 citizens who serve for a set period of time, and then it depends on the state how often they meet. It's not every day. And how it works is that the prosecutor will file an indictment, which is the written document of the charges. Then the grand jury only hears the evidence and witnesses of the prosecutor's side, because they only have to decide probable cause that the defendant committed the crime. Usually the defendant and their lawyer might not even be present at this grand jury hearing. Some require it, so again, it's one of those where it depends on the state. In a grand jury hearing, the prosecutor has a lot more flexibility than in a criminal trial. They can, for example, present hearsay evidence, which they can't do in criminal trials. Hearsay evidence is saying, oh, I heard from this person that they said this. You can't do that in a criminal trial, but you can in grand jury hearing. And they can even present illegally obtained evidence, which you cannot do in a criminal trial. Once all evidence is heard, the grand jury will vote whether to indict the defendant, usually by majority vote. If they do not indict, the charges are usually dropped. Grand juries are often criticized for doing basically what the prosecution wants them to do. Remember, the prosecution has a lot of power in these hearings. So about 80% of the time, defendants waive their right to a grand jury hearing, knowing that the grand jury is just going to end up doing what the prosecutor wants anyways. This speeds up the trial time. Many people say we should get rid of grand juries altogether. So after either the preliminary hearing or the grand jury, we go on to arraignment. Arraignment is when the defendant hears the formal reading of the indictment or an information for states that don't use the grand juries, and is given a chance to enter a plea. Defendants can plead guilty, not guilty, or no contest. With no contest, what they're doing is they're saying they're not admitting their guilt, but they're going to accept the punishment anyways. Not guilty is the most common plea at arraignments. And if you remember, what I said before is I was sat in on arraignment court in Santa Barbara County as one of my internships. And that's where I got to see all of the defendants would go up in front of the judge and they would give their plea, and the judge would read them the rights, and it would go very, very fast. So about 50 people at least would come in a day. So no contest. That is usually a strategy that's used because they don't want to admit guilt in a criminal trial, so then it can't be used against them in a civil lawsuit. That's really where that no contest plea comes in. During arraignment, the judge will also assess if the defendant is competent to stand trial. The defendant at that point will be given an attorney if they don't already have one. So a lot of things happen in this arraignment, which makes it a very exciting court if you ever get to sit in on a court. You can go and watch arraignment court, and it's very fast-paced. But throughout this, there's a lot of different things going on. They get their attorney, they get their charges read against them, they enter their plea. And then also, after that, they will then plea bargain. Maybe. That's why I have the dotted lines around the plea bargain box and a question mark. Plea bargain is not required. They can plead not guilty and go on to trial and sentencing. But like I said before, about 90% of cases are resolved through plea bargaining. So I want to go ahead and take a closer look at plea bargaining. There are 3 types of plea bargaining. The defendant can plead guilty to a lesser offense. The defendant can plead guilty to charges, but the prosecutor will request a lesser sentence for them, even though the judge has the final say. Or the defendant can plead to one charge with the prosecutor's promise that they will drop the other charges. So there are different ways of going about plea bargaining. But keep in mind, this is 90% of the time, this is how cases get resolved, through this type of plea bargaining, one of these 3. Plea bargaining usually depends on the seriousness of the crime, the defendant's record, and the amount of evidence the prosecutor has against them. Like I said, prosecutors do not have to plea bargain. There are no laws or constitutional rights for plea bargaining. And once the defendant agrees to the bargain, they cannot go back if they change their mind, even though in most areas they can withdraw their guilty plea before they are ever sentenced. So why should we use plea bargaining? There's many reasons. It reduces the uncertainty. The offender knows ahead of time what sentence and what punishment they're going to get. Whereas if you go to trial, well, they don't know how that's going to end. It eliminates the need for a trial, so there's less court backlog. Prosecutors are guaranteed a higher conviction rate. They're less expensive than trials. Defendants usually get a better deal than they would have if they had gone to trial. And defendants might be less stigmatized if they take a deal for a lesser crime. I have a really good example of that. One of the kids I used to work with in the correctional facility. At first he was arrested for rape. And through whatever maybe miracle that happened or whatever, the prosecutor ended up plea bargaining with him for soliciting alcohol to a minor, something along that sort. So he got it all the way down from a rape charge to a misdemeanor of giving alcohol to a minor. So I'm guessing the prosecutor did not have evidence, and no, there was no evidence that I knew of that this even happened. It was just rumors going around, or someone told someone that told someone type of thing. But that is one case where this person is now less stigmatized. Think about if they were charged with and convicted of a rape versus taking their charge and being found guilty of giving alcohol to a minor. Big difference in how society sees those two crimes. Plea bargains are not always good, though. For people who are actually innocent, their lawyers may pressure them into taking a plea bargain just to not have to go to trial, even if that might not be the best route to take. So there are some people who are actually innocent. So they want to go to trial. They want to say they're not guilty and be completely found innocent of all their charges. But what might happen is their lawyer might say, no, 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 no. Take this plea bargain just so you have this over with. You'll know for certain what your sentence will be or what's going to happen. Because trial is very uncertain. You don't know how a jury is going to react. So in those cases, I mean, an innocent person might be given a sentence just so they don't go through trial. And habitual offenders. They are often forced into a plea bargain since the prosecutor can basically put them away for life. So this is where you think of basically our 3 strikes, even though plea bargain has been taken out of that. But there's the habitual offenders. I mean, they're repeated offenders over and over and over and over. If they get this record behind them, yeah, they're going to end up having to do a plea bargain. Otherwise, they might get a life sentence. So in that case, it might not be good for society because habitual offenders are getting off easier. And even for okay, let's go on. If the defendant does not take a deal and pleads not guilty, they go to trial. A jury of their peers will decide whether they are guilty of the charges. This process is adversarial, meaning 2 sides are against each other. They are restricted, though, by rules and procedures that they have to follow. In a criminal trial, the burden of proof is on the prosecution to show beyond a reasonable doubt that the defendant is guilty. The defense's job is to discredit the prosecution and raise doubt in the jury's mind of the defendant's guilt. Now, only about 5% of cases are jury trials. Okay? The other 5% are bench trials, meaning there's only a judge. There's no jury. So that's only the 10% of cases that actually go to trial. And then the other 90, again, are the plea bargains. So let's look more at a jury. Having a jury is a Sixth Amendment right. The purpose of a jury is to protect citizens against arbitrary law enforcement, to prevent government oppression, and to protect citizens from corrupt prosecutors and from biased judges. The Supreme Court has ruled, though, that a defendant only has a right to a jury trial if they are charged with felonies or with a misdemeanor that can be punished by at least 6 months in jail. Juries are supposed to be selected from a representative members of the community, the defendant's peers. Now you have to decide for yourself if you think this is actually achieved. The list of possible jury members comes from voter registration lists, DMV records, telephone directories, and utility records. From these master lists, a randomly chosen group is made up for the jury pool, called a venire, and they are summoned by the sheriff to serve. You have to be a U.S. citizen, be a resident of the area of the trial, be a minimum age, usually 18, and understand English. Convicted felons and insane people cannot serve on a jury, and a lot of people try and get out of serving because of financial hardship. So what you end up with is mostly retired people, homemakers, and unemployed people on the juries. Once summoned, then groups of potential jurors are brought to the courtroom where they go through a voir dire, a process that tries to screen out biased jurors. The defense and prosecution ask potential jurors questions about their background as it relates to the case, and if they feel they will be biased, the lawyers can challenge them, and if the judge agrees, they can be dismissed. The defense and prosecution also can use peremptory challenges. These allow them to get rid of a potential juror without saying why. There's usually only a set number of these that they can use, though. So I have never been on a jury, but I have been through that voir dire process, or seen it. I never had the questions asked of me, but I sat in the courtroom while other jurors were asked their questions. And so the case I sat in on was going to be a drunk driving case. So, of course, the lawyers were asking each potential juror what their thoughts were about drunk drivers. Have they ever been experienced an accident because of a drunk driver? Have they ever had a family member injured because of a drunk driver? They'd go very detailed into the different questions of drunk drivers because they're trying to find out if the jurors will be biased one way or the other during the trial. So that's the part I got to see. The final jury is usually 12 people with 1 or 2 alternates. So, going on, this is a chart taken from your book on page 194, and it shows now the general stages of the actual trial. Okay? And it starts at the top, and then it goes all the way through to the bottom. There's the discovery proceedings, the motions, the trial with the opening statements, the prosecutor's case, presentation of evidence, defendant's case, government's rebuttal, closing arguments, jury instructions, deliberations, verdict. That's the fast way. So let me give you a little bit more information. Once the jury is sworn in, the prosecutor goes first and giving their opening statement. Then the defense can either do their opening statement, or in some states they're allowed to wait and do their opening statement after the prosecution is all done. After opening statements, the prosecutor presents their evidence. Then once they are done, if the defense believes the prosecution did not prove their case beyond a reasonable doubt, they can request a directed verdict, or basically ask for the case to be dismissed. If the defense believes the prosecution did their job, then the defense will continue and present their evidence. Once both sides present their evidence and witnesses, then they can rebut each other's sides, meaning they can come back and say, oh, wait, no, this is because of this, or they can argue against what each other had argued in the first place, and cross-examine witnesses. Once all that is done, the prosecution summarizes their case. That's the closing statements. And defense summarizes theirs and gives their closing statements. That ends the trial, and the judge will again give the jury instructions to use when deciding guilt or innocence. And usually those jury instructions will be very specific, laying out, okay, what elements of the crimes had to be proven in order to be found guilty. The jury then deliberates and comes back with a verdict. Usually a unanimous verdict is required, and even if one juror just disagrees, it can be a hung jury, which means in that case the judge declares a mistrial and the prosecution has to decide if they want to start a new trial all over again. So I just followed the lines of that chart and gave you an overview of what actually happens during trial. Going on, I want to at least give you something with the trial rights. What rights defendants have at trial. The Fifth and Sixth Amendment give the defendant certain rights, well, in that trial process we just talked about. The Sixth Amendment gives the right to a public and speedy trial to federal cases, and the Supreme Court then extended this right to state cases in 1967. This right is supposed to protect defendants from long delays that would possibly result in witnesses forgetting what they saw, or witnesses moving away or dying, or the defendant sitting in jail for a long time before they're even found guilty. The Sixth Amendment also says the defendant has the right to have the trial in the state and area where the crime was committed, unless they believe they cannot get a fair trial there. The Sixth Amendment gives the right to confront witnesses. This means the defendant has to be present at trial and given the opportunity to cross-examine witnesses that are opposing them. The defendants also have the right to use subpoenas to force witnesses to appear in court if they have information useful to their case. And then with the Fifth Amendment, it protects defendants from double jeopardy. So they cannot be tried for the same crime twice once they have been convicted or acquitted of it. And those are the main rights that defendants have as they're going through that whole trial process. So this ends our look at our court roles and our court process. I highly suggest you go back in your book, look at the charts that I showed you, and highlight the key different steps of the court process that you need to know.